All right, so we're going to go ahead and get started. I'm delighted to see so many people here. My name is Jason Rantanen. I'm the director of the Iowa Innovation Business and Law Center. I'm also the Hammer Boyd Professor of Law here at the University of Iowa College of Law. So today, it's my great pleasure to welcome Nicholas O'Donnell. Nick is a civil litigation attorney in Sullivan and Worcester's Boston office. His practice focuses primarily on complex civil litigation and art law, and he represents manufacturers, individuals, investment advisors, banks, and others around the world in contract, securities, consumer protection, and divorce cases, with particular experience in the German-speaking world. He's also the editor of the Art Law Report, a blog that provides updates and commentary on legal issues in the museum and visual arts community. Nick is the co-chair of the Art, Cultural Property, and Heritage Law Committee of the International Bar Association and co-chair of the New York chapter of the Responsible Art Market Initiative, as well as a member of the Art Law Committee of the New York City Bar Association. He's one of the leading practitioners in the United States in matters concerning claims to allegedly Nazi-looted works of art. And he's argued before the Supreme Court on the
Guelph treasure,
sold under duress by Jewish art dealers to the Prussian government in 1935. Yesterday, I also learned that Nick has a fascination with natural history museums, which is especially apropos given that we're in the Boyd Law Building today, which is named after Sandy Boyd, who was the director of the Field Museum in Chicago for many years after serving as the president of the University of Iowa, and also as serving as a law professor here at the College of Law. He also taught a variety of courses, but he also taught cultural property here in Iowa Law. So super excited to have Nick here. He's going to be talking today about visual art, fair use, and Warhol versus Goldsmith, the case that was argued before the Supreme Court this morning.
Well, thank you to Professor Rantanen and thank you to Leslie Gannon for the wonderful and warm hospitality here in Iowa City. It's been a great trip, and I'm very happy to be here. I'm going to try to cover a lot of things today. I'm probably going to speak a little too quickly, so I apologize in advance, and look forward to questions and conversation when we're finished. So what I'm here today to talk about is copyright and fair use in the visual arts. Now, copyright encompasses a lot of things, as many as you, I'm sure, know. But fair use existed as a concept in common law that was codified in Section 107 of the Copyright Act. And this is the preamble to Section 107, which essentially says, notwithstanding the other parts of copyright, fair use can exist where the purpose and character of the use, on consideration of the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. That's what we call the first factor. There are, as you can see, 4 factors. What the Supreme Court case today was about, and what has become increasingly important, is this first factor. Now, it is clear from the statute that to find a fair use, the 4 factors must be analyzed as a whole. There is no single factor that is outcome determinative, but one of the things I'm going to talk about is that in the visual arts in particular, this first factor and the corollary interpretation of the first factor of an analysis of whether the work is so-called transformative has become dominant, I'll say. I won't make any more value judgments than that yet. So where does this lead? So 30 years ago, in the case of Campbell versus Acuff Rose music, the idea of transformativeness and fair use kind of finds its home. And the Campbell case was about the rap group 2 Live Crew, which wrote a song called Oh Pretty Woman, which was a spoof or a parody or a satire, depending on whom you ask, of the Roy Orbison song Pretty Woman. And it mimicked the tune, it mimicked the structure. The structure of the song is the singer is observing a woman walking down the street. Now, in the Roy Orbison song, it's relatively romantic. In the 2 Live Crew song, it's a little more aggressive. And the question was whether this was a fair use. Now, in Campbell, this is what the Supreme Court said. It said the first factor in a fair use inquiry is the purpose and character of the use, as I just said. The central purpose of this investigation is to see, in Justice Story's words, which was a case in the 19th century about an autobiography of George Washington, whether the new work merely supersedes the objects of the original creation, citing Folsom versus Marsh, or instead adds something new with a further purpose or different character, altering the first with a new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. And in this phrase, in this quote, the Supreme Court cited the Harvard Law Review article by Judge Laval, who posited this idea that focusing on this idea of transformativeness was the best way to formulate a first factor test. And this was a key moment in copyright jurisprudence. This was about a musical song, of course, and there are lots of other rules that dictate the rights to perform and cover songs that aren't really at issue today. But the court didn't define the addition of new meaning or message in Campbell, nor did it say that this was the exclusive avenue to fair use. And this is a key point to remember, whatever you think or whether or not you agree with me. There is this sort of funny Venn diagram of if a work is transformative, or if a work has a new meaning or message, is it transformative? And if so, is that enough to be considered satisfactory to the first factor of purpose and character? That's kind of the real crux of the debate this morning in the Supreme Court and around this issue in particular. And what I would suggest is that since Campbell, and in the last 20 years in particular, in visual art, courts have really struggled with what to do with this. And the idea of whether something is transformative has both bedeviled and kind of swallowed the rule. So I'm going to talk about a few examples. This is a Second Circuit case from 2013, Cariou versus Prince. And here's the essential background of the case for those of you who aren't familiar. Richard Prince, in 2007, Cariou, about the 6 years that Cariou had spent with the Rastafarian community in Jamaica. Now, Prince tore and pasted these photographs to a wooden board, sort of in a collage format. He exhibited and sold other works through the Gagosian Gallery, which showed a total of 22 of the 29 Canal Zone works in late 2008, all of which used Cariou images. Now, on the left, you see a photograph by Patrick Cariou. On the right, you see one of Richard Prince's appropriations and alterations of that work. He painted over some of the works. He wrote words. He included pornography on top of others, and they did a variety of things with these. Cariou sued Prince for copyright infringement, and Prince and Gagosian argued essentially that these were either compilations, like Feist in the telephone book, that he had simply compiled facts, the fact of the photographs, or in the alternative, that these were fair use. The district court found for Cariou and ordered the infringing works destroyed. Court ruled that the market for Cariou's original work had been damaged by Prince's use, which is the fourth factor. And it really focused on Richard Prince's deposition testimony about his purpose in making Canal Zone, or more to the point, his expressed lack of purpose. Prince, who was a very interesting artist, and certainly, I think, put his finger on the pulse of kind of what we're all uncertain about, essentially tried to take this to the logical extreme. And he said in his deposition, I didn't really do this for any reason at all. I just did it. And so the district court took him at his word and said, there is no new meaning or message here. There is no new purpose or character, because the artist said, there's no new purpose. The Second Circuit disagreed and said essentially that a more objective standard had to be used, and said that asked if the old work is transformed in the creation of new information, new insights, new aesthetics, and understandings. And rather than confine the fair use analysis to whether it is criticism or commentary, which is a phrase that appears in the statute, the Second Circuit focused on this transformative idea and said it must extend to, quote, new expression, meaning, or message. And so that work has obviously cast a long shadow. Elsewhere, and more recently, in the Ninth Circuit, this is a comparison of Oh, the Places You'll Go, the book that everyone gets for graduation, and a Star Trek-themed work called Oh, the Places You'll Boldly Go, inserting the split infinitive as you'd expect. The district court found a fair use. The Ninth Circuit said no. It said that new expression by in itself was not sufficient to be deemed transformative, and just recontextualizing the kind of motifs, the style of the lettering, and that sort of thing was not enough. a little while before that, between Prince and the Star Trek case I'm talking about, this is a case called Keenitz versus Scotty Nation. This is an interesting case, and I'm going to come back to this with a sort of hypothetical later in more recent news events. But this photographer named Michael Keenitz sued the defendants who were making T-shirts using the photograph that Keenitz had taken on the left. This is the 7-term mayor of Madison, Wisconsin, Paul Soglin, who took steps to shut down the city's annual Mifflin Street block party. The T-shirt artists didn't like that, and so they took the Keenitz photograph and they made the image on the right, which if you can't see it or if you can't see it online, says "Sorry for partying." I think it's kind of funny. This case went to the Seventh Circuit, and Judge Easterbrook said that this was a fair use, and really called out the Carriou-Prince decision in the Second Circuit. Judge Easterbrook said, "We're skeptical of Carriou's approach because asking exclusively whether something is transformative not only replaces the list in Section 107, but also would override Section 106(2), which protects derivative works. To say that a new use transforms the works is precisely to say that it is derivative, and thus, one might suppose, protected under Section 106(2). Carriou and its predecessors in the Second Circuit do not explain how every transformative use can be fair use without extinguishing the author's rights under 106(2), and those are the exclusive rights of the copyright holder, among which is to control derivative works. To take it out of the art example, this is why I can't write a sequel to Star Wars just because I want to or because I thought of it, right? That's a derivative work. There's no good reason, this is Judge Easterbrook continuing, there's no good reason why defendants should be allowed to appropriate someone else's copyrighted efforts as the starting point in their lampoon when so many non-copyrighted alternatives were available. The fair use privilege under Section 106 is not designed to protect lazy appropriators. And it pulled out part of Campbell, in which Justice Souter had said, if the commentary has no critical bearing on the substance or style of the original composition, which the alleged infringer merely uses to get attention, or to avoid the drudgery in working up something fresh, the claim to fairness in borrowing from another's work diminishes accordingly if it does not vanish and the other factors, like the extent of its commerciality, loom larger. And so what you see here, I'll get to him in a minute, is this tension, which I want to take a step back for a second and talk about, right? And people kind of claim the mantle of what copyright law is about frequently, and you can come to your own conclusions. But for one, I will caution you, if you were reading reports that suggest that the Constitution mandates copyright law, it doesn't. It authorizes it, and it authorizes it in the promotion of the useful arts. And I think a fair interpretation of copyright law is that it is an attempt, whether good or bad, to strike this balance, because copyright law, by its definition, restricts expressive activity. It says, I can't write that Star Wars sequel just because I thought of a really cool one. Somebody has the right, in some respect, to restrain my creative activity. But the whole point is also to promote creative activity. So there is very much a paradox here. And I'll get to the argument today later, but Justice Kagan was sort of wrestling with this morning of, isn't the whole point to promote creative activity? And it's a little bit of a conundrum because it isn't. If it were, then there would be no restricted. Now you could say that the incentive is provided by the restriction, but the restriction, of course, is a restriction. So now we get to this fellow. Now, this photograph was taken by Lynn Goldsmith in 1984 of Prince. And at the risk of being the old guy in the room, Prince in 1984 was a really big deal. He was a really remarkable musician. He was somebody who came along and had just incredible guitar skills, incredible charisma, and in this sort of moment between the end of disco and hair bands and new age synthesizer music, he just had this incredibly distinctive sound, and Purple Rain, the album, was like a comet. I mean, it was in the air for 9 months. You couldn't sort of not hear Purple Rain or When Doves Cry or anything else. And so here he is. And Lynn Goldsmith takes this photograph and several others. She took this one in 1981, excuse me. But in 1984, people start writing about him because the album has just taken over. After the shoot in 1981, she had licensed various images from that shoot to a variety of magazines, including Musician, People, Reader's Digest, and the Smithsonian Catalog. As a result of this, and the other thing, of course, is the movie, which you should all watch, which is incredible and very bad. But I think it sums up Prince perfectly in the sense that the absolute flex by Prince is the plot of the movie is essentially this ongoing feud between Prince and the Revolution and the band The Time over the affections of Apollonia. And The Time is also a really awesome band. And the utter self-confidence to put a band that good in your movie and just sort of assume that you prevail by playing the songs consecutively it's kind of Prince. Vanity Fair in 1984, as a magazine reporting on pop culture and various things, commissioned Andy Warhol, famous pop artist, to make an illustration for its article called Purple Fame. Vanity Fair licensed the Goldsmith photo you see here, quote, for use as an artist reference for an illustration to be published in Vanity Fair, and agreed to credit Goldsmith in the magazine along with Warhol's silkscreen. So this is, the genesis of this is important. There was a lot of this discussion at the argument this morning. Warhol didn't select this photograph from the entire universe. Vanity Fair selected this photograph to be the source of the Warhol painting that it wanted. Warhol then made a series of Prince silkscreens, including the Purple Prince one that appeared in Vanity Fair. This is the Orange Prince, which is the subject of the current case. As you can see, Warhol's prints reproduced from Goldsmith's photo Prince's head above the shoulders. He adds color to Prince's face and to the background. The lines of Prince's hair at the edge are made a little more jagged by these. Do I have a pointer here? You can see the kind of white silhouette lines at the edge and parallel lines in a brighter color. The case that was litigated this morning is not about whether Warhol had a right to use Goldsmith's photograph in 1984 to make Orange Prince or Purple Prince or any of the other prints. There are Prince, there is Richard Prince, and there is Prince, and it's very confusing. So, Warhol didn't need permission because Vanity Fair had gotten the license for use in a magazine illustration. So, the works that were created in 1984 for Vanity Fair rested on a license to which the photographer had agreed. The current dispute arose because when Prince died in 2016, and like in 1984, it was the subject of a great deal of news coverage, the Condé Nast magazine sought permission from the Warhol Foundation. Now, when Warhol died in 1987, a lot of his art and control of his copyright passed to the Andy Warhol Foundation for the Visual Arts, who is the litigant in today's dispute. So Condé Nast went to the Warhol Foundation and said, can we get a license from you, the Warhol Foundation, for this image to go in Condé Nast magazine? The terms of that, I don't know, but it happened. This ran on the cover of Condé Nast, and Goldsmith's name, as you can see, is not mentioned. I don't have the Purple Prince here, but in the original one, there is a photo credit visible in the image itself to Lynn Goldsmith. When Goldsmith found out, inquired, a discussion ensued about whether the Warhol Foundation ought to pay Goldsmith and her licensing company a license fee, and then the Warhol Foundation sued her. She counterclaimed for infringement, again, arising out of the 2016 use, not the original use in 1984. The district court in the Southern District, Judge Cottle, held that the Warhol prints were fair use, but the Second Circuit reversed. And the Second Circuit said a couple interesting things with respect, again, to the factors. Now, the Second Circuit went through all four factors and ruled in Lynn Goldsmith's favor. The only question that was presented to the Supreme Court was about the definition of transformativeness. There was an interesting colloquy this morning with the government's lawyer about what should happen hereafter. This is an interesting thing and important one for future litigators. You always have to think about what comes next. And even no matter which side wins, the Supreme Court could affirm, the Supreme Court could vacate but essentially hold for Goldsmith but remand And then the question will be how much of the prior Second Circuit ruling has to be redone, because if it's vacated, it's not there anymore. So do they have to go through all 4 factors again, or just the first one, which is what the Supreme Court took up? The government, as I would submit only the government can, because time is less of a factor for the government, which exists in perpetuity, said, well, sure, you could do all 4 again, which I'm sure the litigants were saying, no. But anyways, the Second Circuit, this is before it goes up, says, there is no meaningful dispute that the overarching purpose and function of the 2 works here is identical, not merely in the broad sense that they are created as works of visual art, but also in the narrow but essential sense that they are portraits of the same person. This is an important copyright point. This is an important legal strategy point. Framing the question is a lot of the battle a lot of the time, right? And so what is the purpose and character of this work? What is the purpose and character of this work? You can look at this from a lot of different ways, right? This was a photograph of Prince. Now, this is not just a photograph, right? This is a photograph that was taken in a studio with careful lighting choices, wardrobe choices, hair and makeup choices, all the rest. One thing I thought was discouraging this morning, and to be clear, Philippa Loengard and I, who is a copyright scholar at Columbia, filed a brief in support of Goldsmith in this case, as you've probably sort of inferred from my remarks. But my interest primarily is in a standard that is workable and makes sense. I think fair use is incredibly important to the creation of expressive works. And again, I'm going to show you a few tongue-in-cheek examples later. But this is not happenstance, is the point, right? Photography is copyrightable expression. And this photograph, which catches him in a particular moment, was staged, posed, very much a product of Lynn Goldsmith's choices. One thing that I thought was interesting, and maybe not just playing with the advocates, it was the Chief Justice this morning, was talking about the 2 and was essentially saying, he didn't use these words quite, but he sort of said, well, this is just a photograph. If you wanted to know what Prince looked like, you wouldn't look at this, you would just look at this, because this is what he looks like. But this is a choice. This has sort of a stamp of an artist. And one thing that's been very hard to separate in this case, and this is not a critical remark of anybody, but it is very hard to unpack from the conversation that this is an Andy Warhol who is really famous and whose style is very distinctive. And one of the challenges, which I think all the justices were wrestling with, is how do you create a test that's not just, this is a famous artist, he wins? Because not only is that bad, but it's also impossible, because Andy Warhol was famous when he made this, but he wasn't famous when he made the soup cans, or as famous, right? And so at some point he became Andy Warhol, but I think what all the members of the court were grappling with in a good way is, how do we set the rules, and both sides were arguing in very different ways for it, how do we set the rules for an artist today, right? If you're creating something today, how do you know what you can do and what you can't do? And I think what's so hard about that is the Warhol Foundation's standard that they've advocated for builds off this language in Campbell, which is that if it has a new meaning or message, it is transformative, and therefore it is fair use. And I think it's worth going back to Campbell and thinking about that, because Campbell was talking about a song which was backwardly referential to the work. And it's hard to compare a song and a work of art, because they're very different. And it's easier to hear 2 songs which have similar titles, which have a narrative in spoken words, right, about the same topic. You've got 2 human beings, a man and a woman, they're walking down the street, one is looking at the other, and then they're saying very different things in the 2 songs. Is this work commenting on this? No, I don't think so, and I don't think the Warhol Foundation really was suggesting either that it is. What they are saying is, it is so different. These elements that I talked about, the color in the background, the flat orange or purple relative to the white field, the cropping of the head. I mean, it's always been true when you're looking at the first factor that with the 4 factors that you talk about the substantiality, right? If I made a silk screen of, this here, and blew it up and did something, well, then I've copied a much smaller portion. So there are mechanical aspects to an infringement claim that aren't as much at issue here because Warhol took the whole head, but he didn't take the whole image, to be fair. But does this work add new meaning or message to this work? The Warhol Foundation says yes, and the Warhol Foundation says essentially that if that's true, you've satisfied the first factor. What we certainly tried to argue in our brief, and Goldsmith's team has argued, is that basically swallows the rule. Because let's go through a few examples. All right. And one of the things that came up in the briefing from various amici is trying to grapple with what various rules would mean for better known examples of visual art. So this is a painting that many of you have seen. It's by Hieronymus Bosch. It's in the Prado. It's called The Garden of Earthly Delights. And I raise this, and we talk about this in our brief, as an example, playful perhaps, of the difficulty of applying a meaning or a message standard as the criterion for transformativeness. So this painting was in a 2001 exhibition in the museum, the Boijmans van Woningen Museum in Rotterdam. And there were two curators who wrote articles about this in the same exhibition, okay? One of them, whose name was Paul van den Broek, describes the center panel, right there, as, quote, a depiction of what paradise might have been if Adam and Eve hadn't spoiled it. Whereas the other curator, Coldaway, says that it shows the dangers of the world they live in and the false paradise promised by unbridled sexual pleasure. And to that conclusion, Van den Broek, the first one I mentioned, described his co-curator's analysis as, quote, ridiculous. This is a really well-known work in the canon of Western art, right? Two highly respected old master scholars assigned different meaning and message to the same painting. And the way I've come to see it is, we've all been in high school English class, right? And if the test is, can you plausibly come up with two different messages, the answer will almost always be yes. And more to the point, who gets to decide that? Who gets to decide if the meaning is new enough or different enough? If it is only that it is different, then you don't need much analysis, I think, because you just have anything greater than zero. If it's a matter of significance, then I think you get into a real challenge. And I think Justice Alito had some telling questions this morning, which I thought were illuminating. He asked essentially, who gets to decide what is new meaning, what is new message? And the Warhol Foundation's answer essentially was, you could have evidence, you could have expertise. But the way I look at this, which is worth what it's worth, is, again, we're trying to talk about, okay, if Hieronymus Bosch walked to the earth tomorrow and wanted to create this, or Warhol wanted to create his work tomorrow and nobody had ever heard of him, how would he know what he can and can't do? And if it takes an expert after the fact, that's not very useful guidance. And it's not very useful guidance as a rule of law, and it's terrible guidance as a practical matter. I am a practicing litigator, okay? Litigation is very messy, it takes very long, it's very expensive. And in very few cases do clients have the resources or the will to litigate a question to find out the answer, right? Even in a business context, if there's a lot of money at stake and it's, quote, worth it, that gets very difficult to do. This is an example we cited in our brief. I think we view it as a counterexample, which is, that is not to say that adding new meaning or that focusing on the purpose and the character of the work will lead always to infringement, right? So this is Las Meninas by Velázquez. You can't see it as well on the slide here, but in the background of this painting, so a few things. This is the Infanta Margarita in the front there with her attendants. This is Velázquez. He's looking right at the viewer. This is the king and queen. They are standing at the back of the room, basically where you are, and that's a mirror. And so it's, again, a real power play, because in this room is, I'll give you the artist, forgive me. No, that's not it. This is a room that, this painting depicts an actual room in the Cuarto de Príncipe in the Alcázar castle in Madrid, where the king and queen lived. And these rectangles that you see on the wall are actual paintings. They are paintings by Peter, they are copies, this is a secondary copy here, right? They are copies of Rubens, Peter Paul Rubens, Ovid's Metamorphosis cycle by a different artist. And so what Velázquez, at least one interpretation of this, one I ascribe to, is the Spanish crown was a patron of Rubens, who was the greatest painter of the Baroque era. He was the ultimate status symbol, right? Rubens and copies of Rubens are hanging around the wall that the king and queen bought from Rubens. And Velázquez is saying, look at me, right? I'm the one here. I've arrived. I am the greatest painter in the world. Now, he's copying those paintings. He's copying the copies of the paintings. But to me, that fair use, if this were a painting created tomorrow and everything was under copyright, is obvious. This is an example. These are two examples cited by the museum brief that was filed in support of the Warhol Foundation. This is a work on paper, I think it's a pastel by Jean-François Millet, called First Steps. And this is a work by Van Gogh, First Steps after Millet. Now, it's clearly referential. And I don't see this as an obstacle to fair use in the sense that, I mean, there's a debate, I suppose, as to how much copying there was here. I think there's a lot of elements that are different. But if you focus on the purpose and character, then I think you get to the right answer. And so that's sort of what this morning's argument was about, and I want to go through some of that commentary. I think what was interesting to hear the justices this morning was, that's the punchline. So, but this is the point, right? Which is, this is a news photograph on the left of Governor Ron DeSantis recently after Hurricane Ian, right? And he got a lot of grief about the boots. The purpose and character of this copyrighted photograph is to depict the governor in a newsworthy event walking around after a disaster, right? Like the Keenan's Scotty Nation sorry for partying image, the purpose of this image is to make fun of the governor. I don't think those things compete for similar markets. And again, I don't think the purpose and character is terribly hard to discern. Now, for this came up in the oral argument this morning as well. For this image, you need something like this to make your point. And the last part of the argument this morning, which Justice Gorsuch kicked off with the government's lawyer, is essentially how much does it matter, or should it matter, if the secondary work creator needs the first work, right? You'll go back to what I said before, which is that Warhol didn't pick the photograph of Prince. He was given it by somebody who had acquired a license for it. And notably, I think, for the Warhol case, Warhol got in a lot of trouble for using other people's photographs early in his career. And he stopped doing it after he got sued a couple times, and he started taking his own photographs. He sort of adapted to that and created the source material. This balance has to grapple with who controls that source material. And I thought a telling remark this morning was when the Warhol Foundation's lawyer, who did a great job, as did Lisa Blatt for Lynn Goldsmith, said essentially there has to be a supply of raw material for creative expression. That's the phrase he used. And to me, that gives away the game, right? Art is not raw material. Art is art. Copyrighted expression is not raw material. It's copyrighted material. And so Warhol made a choice, right? Warhol made a choice to use this image to make this image. Warhol, maybe there's something about Lynn Goldsmith's work that's so critical to the message of consumerism or popular culture that Warhol wanted to make. But if there is, then to me that's kind of the point, which is that means Goldsmith has done something fundamental and original enough and copyrighted that the derivative use is something she has the right to control. Contrast, somebody saw this image and it reminded them of the sexy green M&M. And that was a function of just the way the image was composed. I don't think you need to get into what was the photographer trying to do, because this is a copyrighted and copyrightable work, and that deserves respect. This is different than Goldsmith's photograph in the sense that this photographer didn't pose Governor DeSantis like this for a particular set of choices. I think Governor DeSantis would probably have that undone if he could. But it happened, and catching it is a notable work, and seeing something and deciding this is the moment that I think will resonate with people, that's what gets this person protection. That's why licensing is so critical to photographers, because depicting this image, take the M&M joke out of it, if there's something newsworthy about this photograph, if there's something about Governor DeSantis' response to Hurricane Ian that becomes part of his political story, okay? Think about photographs of Bobby Kennedy or Martin Luther King or something else. Those moments, the photographer's ability and prescience to see those moments and take them, that's what they deserve the credit for, and they get the licensing fee for. And if you take that away, then I could take this picture with my phone, sure, but I'm not going to fly to Florida after a hurricane just to take a photograph. Somebody's there. Somebody's got cameras. Somebody's got equipment. So it may seem funny to you that I'm arguing that this is a fair use when I'm also supporting Lynn Goldsmith, but I think it has to come back to the purpose and character, because these purposes, I think, are different. I think these purposes are, in a narrow sense, the same. Lynn Goldsmith took a photograph, licensed this photograph, and many like it, for magazines. She did that before Prince was super famous. He was already well known, but before he was as famous as he would get to be. And she captured this guy in his meteoric ascent, right? And so when he got there, she was sitting on, this mother lode of powerful images. Vanity Fair saw that and agreed, essentially. Vanity Fair said, this is what we need to use as a platform for a second level of comment. And that's good. It's good that this image exists, right? Warhol is making his own expression. I would agree that he has a new meaning or message. But if that's all you require of him, then the licenses that Lynn Goldsmith, or somebody much less well-known than Lynn Goldsmith, sell for a living, that market essentially collapses. Because why would you ever buy a license? I mean, literally, why would you ever buy a license if this level of alteration gives you the right to use it in whatever capacity you want? I think, over the span of the market, I think the answer is you probably wouldn't. So I did listen to the oral argument this morning, and I recommend that you all do the same. It's recorded. You can listen to it on the Supreme Court website or on oye.com, which also has a transcript that goes with the audio, which is a nice feature. And I'm not going to tell you what's going to happen. I think the justices were very impatient with the broad meaning or message test. They weren't all the way there with Goldsmith either. They were very interested in what the government thought. The government supported Lynn Goldsmith. Essentially said the Second Circuit result was right, as the government often does. They said, well, you shouldn't say it's never a fair use. You should leave some room. I thought the most interesting exchange of the day was with the Warhol Foundation's attorney. Justice Thomas was asking a series of questions. Now, Justice Thomas had an interesting dissent in the Google versus Oracle case, which was about software. And I'm going to read you that quote. So the Google versus Oracle case, the software was copied, but the court, with Breyer writing for the court, held that it was transformative because it was being used for something else, and that was enough. Justice Thomas dissented from that decision, which was just last year. He says, the result of this distorting analysis is an opinion that makes it difficult to imagine any circumstance in which declaring code will remain protected by copyright. And he started the whole argument today, Justice Thomas did, asking Mr. Martinez, can you name a work of art that would fail your test, that would ever be infringing? And he did not give any answers in response of visual art. He referred to adaptations of movies and literary works, which is an interesting choice. because of course this case is about visual art, but the result will be about what Section 107 means, and Section 107 applies to all copyrighted material. But the last thing I'll leave you with, and then I really do look forward to anybody's questions, is Justice Thomas, not known as a jokester, really brought down the house because he was pressing Mr. Martinez, and he said, okay, what if I take this image of Prince, the Orange Prince, and I'm a really big Syracuse fan, and I take this to a Syracuse game, and I write "Go Orange" on it, and I just hold it up, and I wave it around. And I thought it was a pretty good example, actually. I thought that kind of proved the point, which is because the Warhol Foundation insisted that that wouldn't be a fair use, which I don't think is consistent with their position in this case. So, you know, I don't know what's going to happen. I think it was a very interesting argument. I really enjoy arguments like today, where there's no particular ideological question at stake. I think the justices all really enjoyed it and were interested by it, and didn't regard the answer as obvious, which is a very interesting and thought-provoking intellectual exercise. Typically, these decisions will probably come out in 2 or 3 months unless there's a lot of contention. So, like I said, just to sum up, I think if you stay focused on the purpose and character, you get to a better result, because meaning or message is just a little too broad for my taste. So that is what I want to say about the case, and would welcome any questions that any of you have.
Hi, thank you so much for coming and speaking on this topic. It's really an important and interesting one because this is the first time we're getting Supreme Court talking about transformativeness in the context of visual art. It doesn't have the words to kind of give the narrative, as you said. But there's a couple other questions I had about that. One is, do you think that this is a shift from using the audience perspective to maybe thinking back to the artist's intent? Because we've had so many shifts in the parts of copyright, trying to focus on the reasonable objective or the reasonable observer or some other aspect that's more audience focused. Is this a shift to artists? And the second is, do you think there's any chance of clarify that the conversation about lessening the second and third factor of fair use that we had in Campbell versus Cup Rose is about parity and not transformativeness, which all the lower courts seem to get wrong?
The question is about, is this going to return the focus
to artist intent, and then will this kind of readjust the importance of the second and third factors? You know, it's a really interesting question. There were a number of questions today that seemed to me to indicate maybe a consensus that the subjective intent of the artist was not what they found useful as a test. But the problem is whether you're talking, you know, as I and others have suggested, about a purpose and character focus or meaning and message focus, which is what the Warhol Foundation asks for, you do, to some extent, have to decide what you think the artist thinks, right? What is my purpose in coming here today? I'm speaking to all of you. Hopefully I'm being interesting, right? You can infer that from my actions, right? You don't have to read my mind. You don't need to take my deposition. And I think they were, I don't think they have made up their mind yet. I think several of them, I mean, I thought Alito and Thomas were the most critical of the Warhol Foundation. Sotomayor, I thought, was also pretty tough on the Warhol Foundation and was very impatient with their answers about the effect on photography and licensing in particular. I don't think, though, the rest of them heard quite what they wanted to about how you get to decide. I think, so I don't quite know the answer yet, I'm afraid. It's a rambling way of saying. Yes.
Remind me of like Dada art, where it's basically like the one I was thinking of was the Duchamp one, where it's Mona Lisa with the mustache on it.
Yep.
I'm just like, is there a difference because those are more contemporary examples, whereas this one, I mean, would say this was happening nowadays, like this is an older example, I guess there's no one you really could bring a claim against, or do you think that that would change, I guess, more historical examples if someone was using, you know, an older work that there's no estate to really argue on behalf of?
right? I mean, that was part of the museum brief. the point they,
were arguing is that they were using classic examples of Western art. Neither of these works are protected by copyright anymore, but they were trying to say that if Goldsmith is right, this image would infringe this image, and therefore Van Gogh wouldn't make it. I don't know if Van Gogh actually titled this after Millet, or if that's sort of what it's become known as. You know, and I think the Dadaist examples got cited in a number of places. But, you know, Dada, this goes back to your point, right? You do have to make some conclusions about artist's intent to a certain extent, right? Marcel Duchamp was not trying to depict the subject, the woman, the human person from the 16th century. He was depicting a uber famous work of art in the context of the art market. I think those are different purposes. It's not the meaning so much. And I think it's okay to err on the side of a generous interpretation of what the different purposes are. I just think, you know, a lot of people, myself included, were scratching our heads as to why they took this case, because I think this case creates the potential for a really bad rule about photography in particular, which is an important industry that nobody reads the newspaper anymore except me, but you know, newspapers have photographs, the internet has photographs, and everybody rips those photographs off, and that's a cultural thing now. But that doesn't mean it's okay under copyright law, unless Congress changes it. But I think, you know, and I would say the same thing for these, not for this silliness, but I would say the same thing for this. I would say the same thing for Las Meninas if that were there. I mean, it's you should be generous in your interpretation of the purpose, because you still have to go on to the fourth factor, right? You still have to decide what the market displacement is. And I hope, to your point, I hope that part of this cuts down the almost outcome determinative aspect of the first factor in visual art since Cariou in particular. It's sort of become, is it transformative? If yes, fair use. I worry in this case, it was sort of an undercurrent of the Cariou case too, of does the fame of the secondary artist mean they win the fourth factor because, oh, well, Patrick Cariou makes nice coffee table books, but he's not Richard Prince. Same thing here. So that you know, it will also be interesting to see how much of this they send back for determination, or if they just reach the first factor analysis and sort of do their Delphic thing and leave it at that. Yes.
Back and forth between the picture of the governor in Florida, and you said that was, you know, a desire for fair use, and then go back to Prince's or Prince of Prince, and saying that no fair use, and you were pointing to what made both of those copyrighted in terms of your point towards the vision, the creative subject matter in Prince, and then you were pointing to the timing in Governor Photo. I was curious whether or not you found, like, whether depending on what provides the visual art, it's copyrighted subject matter, whether or not that has a way into what, whether or not fair use is applicable. There's no way to word that. Do you favor something having, you know, a rendition plus the other subject matter that over just timing?
so, I mean, I think that goes back to just section 106.
In section 101, which is this a creative work of expression fixed in a tangible medium? The answer to all of these is, I think, yes. And there's some interesting cases in the Ninth Circuit and Second Circuit about a photographer who took a photograph of Death Valley. But to some extent, that question was sort of settled in Burrough-Giles, and I think one interesting thing about the Warhol brief is that they were kind of subtweeting that case, which is there was a lot of, and this is why I took the Chief Justice's comments, I took notice, because there was a lot of, is it really that much of a choice to take someone's photograph, implicit in that argument, which I certainly don't agree with. But I think in any of these instances, you get enough of that. I mean, DeSantis photograph, you've got, the photograph 1 second after this and 1 second after that and 1 second after that are all a little different. And in any newsworthy photograph, you're going to have some projection by the viewer based on what they think of the person being depicted, I suppose. Is this a decisive pose? Is this a silly pose? But there too, right? That you're going to have essentially infinite meanings or messages. And so would that be enough? I don't know. Yes.
Okay, so a question online I'm going to ask, which is Vanity Fair paid Goldsmith a license fee for the creation of the purple image. Should that past license fee be given evidentiary weight as an admission that a license is appropriate for the new orange image?
I think the answer is yes.
I mean, I think it's an ongoing conundrum of just because you asked for a license or got a license doesn't necessarily mean you couldn't have used it as a fair use. It may be simpler, it may be less hassle, depending on the photograph. The license fee may be de minimis, and you just decide it's not worth trying to prove a point. So I think it does, and in Warhol's case, I look to the broader view, which is, like I said, he used lots of images and ultimately came to the conclusion that he needed either to make them himself or license them, which is mostly what he did by the end of his life. Yes.
With visual art versus other types of art, how do you feel like this plays kind of into that the visual art, maybe we can't be using the same kind of ideas as other kinds of art. Why is that?
Well, I think it's a question of the application, right? So if I write a book and the book has characters, right? I can't write a sequel to Kill a Mockingbird. I can't write a book about the sad late career of Atticus Finch and his disillusionment with the legal system, like all litigators, right? Because Harper Lee's estate owns that derivative right. That's a lot more obvious, right? And so to what extent is a work of visual art derivative? This is sort of the $64,000 question. And I think really, it's not that I think Congress is always right, believe me, but I think that purpose and character test is the balance for the first factor. Because if you're using it for a similar thing, like with Warhol and Goldsmith, then I think you're really on thin ice with the secondary use. If you're using it for something else, to illustrate a specific famous musician in a magazine at the height of his fame or at the moment of his death. That's how I frame the question. I think in many, many cases, maybe even most, the purposes might be sufficiently distinct that it's okay to err on the side of fair use. Because you're not doing something so obvious as, Holden Caulfield's retirement party. It's because I say this as a field art historian as much as a lawyer. It's really important for visual art to comment on other works. I mean, that's part of the Western tradition. That's what Velázquez is doing. He's saying this other guy is a big deal, and I'm a bigger deal. And he's saying lots of other things too. That's unquestionably good. And if that were, those were two copyrighted works today, I think that should be a fair use.
All right, I'm going to ask my question, which is, so let's say the purpose and character approach. How do you advise an artist who's trying to figure this out? I mean, because the artists, they're not always going to have lawyers by their side. They usually won't.
Yeah.
How do you advise an artist, or what does the artist do? How does this make things clearer for the artist than the current test?
So I think the first advice is,
if you're just talking about copying another work of visual art, I think you have to understand that you are already embarking on a less certain endeavor. And if that's the kind of expression you want to do, that's fine, but not everything is risk-free. And then, I think there's a way to formulate it, which is to say, look at what you're trying to do and where you're trying to do it. If you're each selling works of visual art, and you're copying the image wholesale, on another work of oil on canvas, then you should probably be a little cautious. If you're copying less than the whole and other elements, make it much different in that, again, without thinking about the artist's intent, but the purpose of this work is different because the work is so different, then I think you're safer. It is a problem, and as a practicing lawyer, it's a problem. I just think it would be better than where we are now, which is in the transformative nature. I mean, I suppose it would be simpler to say essentially transformative equals fair use. I think that would provide clearer guidance in a bright line sense. But I don't think it's consistent with section 107 as the problem. So until you change the law, I think you've got to stick with it to an extent.